In 2011, we passed a House bill, prime-sponsored by Representative Jeannie Darneal, that, among other things, created a task force to look at the treatment of juvenile criminal records. It was a bipartisan task force made up of both Senate Republicans and Democrats, as well as House Republicans and Democrats, and stakeholders throughout the legal and child advocacy community. The task force developed multiple recommendations, one of which was the language that is now Senate Bill 6292. The problem that we were trying to address is a lot of juveniles who commit relatively minor offenses end up dealing with those for much of their adult lives, whether it's when they apply for employment, search for housing, apply for college scholarships or admittance to a university. These criminal convictions oftentimes significantly disadvantage folks who are trying to move on with their lives. Our juvenile criminal system is meant to be largely rehabilitative in nature, so this bill helps us accomplish that and allows these young people to get on with their lives. All crimes will not be held confidential. The bill creates a presumption of confidentiality with several exceptions. The most notable exception is that all serious violent offenses committed by juveniles will not be confidential. This is important because obviously we have to weigh the interest of the juvenile in trying to allow them to be rehabilitated and move on to their life with all of our legitimate interests for public safety, so that business owners that are seeking to hire young folks, landlords potentially going to rent to these people, that they, if a real serious crime is committed, that they understand that and they understand the risks that they might be putting their employees into, their customers into, or their other tenants into. There's also an exception written where any party to the case may make a motion to the court asking that the judge weigh that very issue, weigh public safety and the interests in full disclosure with what it is we're trying to accomplish with regard to benefiting the juvenile at issue in the case. That analysis will allow the judge to look at specific facts in a case. So a crime, while maybe minor on its face, the specific fact pattern of that particular case might present circumstances that seem more egregious, and that a judge may then want to allow those records to be open as a result. Everything we do here in the legislature is a balancing act. On the one hand, our juvenile justice system is meant to rehabilitate these young people. We're not trying to grow career criminals. One of the number one causes for recidivism or a reoffending for a young person is to be incarcerated and to develop this pattern of career criminal behavior. So this bill tries to address that by literally giving a young person a fresh start. However, we clearly have a public interest in understanding where risks lie and who might pose a danger or a threat to our neighborhoods, our communities, our businesses, etc. So this bill tries to strike that balance by creating this presumption of confidentiality, but by creating reasonable exceptions and giving the judge in the case wide discretion to make decisions based on the facts presented in that particular charge and the young man or woman who's the accused.